or manslaughter, or second-degree murder, put the word murder in there, or first-degree premeditated murder.
Yes, sir. Should be.
I'll now define those crimes for you for the purpose of that element. Turn to the next page, you'll see the new introductory paragraphs in it. Aggravated assault, the other ones all mirror this. The offense of aggravated assault contains, I should say contains, for that reason, certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit aggravated assault at the time of the burglary. And then I go on with the standard definition of aggravated assault. And that carries out throughout. Second, with aggravated battery, the same thing. So let me make those changes. Contains certain elements.
Your Honor, page 8, where it says the end of that first paragraph, first three elements to define aggravated assault.
Correct, thank you. No. The first three elements do define assault. It's the fourth
Right.
element that makes it aggravated. That's standard language right out of the model instruction. And then I use that same introductory paragraph, just modifying it for the specific crime in question each time it is used. When I get to first-degree premeditated murder as the subset of burglary, I refer them back to the previous one because that would apply. The previous definition that they've got would apply. But I do say in there that it was actually premeditated murder upon Robert Baker, just to make it clear that they understand that. And then the page reference to page 4 is the reference to the definition previously given of Robert Baker for first-degree premeditated murder. Any objections to how I made those changes, State?
No, sir.
Defense? Subject to prior.
Yes, subject to the prior objections, Your Honor, and the culpable negligence is still on page 10, or is that instruction part of the?
Culpable negligence was defined for the very first time on page 10. I believe.
Yes, sir, that's correct.
And so what I did was I used there's a way of creating cross-references within Word. The first time the term was defined, I created it as a cross-reference mark point and then cross-reference back to the page so that the jurors would know where to look. We don't have to do that, but I think it makes it easier for them. Any questions about the lesser includeds then of count 1?
So, I'm sorry, just for clarification, so the lesser included to count 1 stop on page 11.
No,
It continues.
no, that's just your burglary. The lesser includeds begin on page 13. And then moving on to count 2, if there's no objection to count 1 other than as stated.
Just renewing all previous objections, Your Honor.
Understood. So count 2, I just made the same changes. No change to first-degree premeditated murder. First-degree felony murder, I made the same changes to the burglary intent crimes. And have defined them each to include reference specifically in this count to Tatum, not to Robert, and only to him. And then on first degree, premeditated murder referred specifically to the earlier description of, with regard to Tatum in this count. So cross references to that page instead. Any questions about any of those instructions?
No, Your Honor.
Lesser included are the same, second degree and manslaughter. And then that takes us to count 3. Anything else on count 2 then? See,
I'm sorry, Judge?
anything else with count 2?
No, sir, I was already looking at count 3, I'm sorry.
Defendants, anything else with count 2 other than previously stated? And preserved?
No, Your Honor, just resting on the previous objections.
Okay. For count 3, when we get to burglary, this time, since we have already defined aggravated assault, aggravated battery, manslaughter, second-degree murder, and first-degree premeditated murder, I'm simply telling them to refer to those instructions again.
Yes, sir.
I do the same thing for count 4 as a preview.
So Judge, just on page 30 of 47,
Okay?
it says even though an unlawful remaining in a structure conveyance, they probably should just have the
I'll take
conveyance struck
conveyance
out.
Thank you.
Yeah, I'll look and see if it's on the corresponding page for count
Let
4.
me just do a quick search here.
Oh, okay.
It is. Thank you.
Yeah, no worries.
And now it's gone.
And what, sorry, there was a
The
little.
word conveyance was inadvertently left in on on page 30, next to the word structure. Any other changes with regard to count 3? The one lesser included is the trespass while armed.
No, sir, not for the state.
No, Your Honor.
All right. Looking at count 4 then. Neither of you caught this. I made a big mistake this morning. When I did my copy and paste, I didn't change out the description of burglary while armed. It said burglary while with assault or battery.
Yeah.
And still said it was count 3. So this has been fixed now. This is now burglary while armed, which is a separate offense.
I feel like we failed the test this morning.
Well, we all did that. Now, in element 2, I'd like to point out at the bottom of page 34,
Yes, sir.
after entering the structure remain with the intent to commit or attempt to commit, and I used the same list there. aggravated assault, or aggravated battery, or manslaughter, or second-degree murder, or first-degree premeditated murder. And that is the same elements in the previous one as well.
Yes, sir.
The lesser included is trespass while armed. Anything else with regard to count 4 from the state?
No, but I. Assault or battery. It should be the non-trust. It should just be trespass.
On page 30.
Count 3. What page?
I don't know. No, sir. I think we need to take that out. I'm sorry.
All right, I'll take that out of the verdict form as well.
The defensive requested.
The armed?
Well, you don't want
the aggravated?
trespass while armed when we didn't charge an actual armed in that count. That would be right.
Right, the count 4 is while armed.
Understood.
Okay. Didn't think you wanted it. So I do need to know, but I don't need to know whether it was armed, so I'll take out that paragraph.
Yeah, the
Right.
dangerous weapon. Yeah, I think it goes all the way from dangerous weapon down to great bodily harm. You can take all that out, Judge.
Okay. But that all stays in for count 4.
Yes, sir, because count 4 is the actual one with the fire.
Open up the
with the
verdict
weapon.
form and fix it as well, because the verdict form does not need it. Lesser included is whether any more alibis on alibi, I mean unspent rounds on number 3.
No, sir.
All right, moving to number 4, anything else in the state?
No, sir, I think we caught all.
Defense, anything on count 4?
Come on.
Paragraphs 6, 7, 9, and 10. I don't believe there's been any suggestion of those being raised with any witness. There was a question about prior inconsistent statements, so paragraph 8 would stay in.
Yes, sir.
Defense, do you object to those being, those changes?
No objection.
I am I've removed the paragraph about the defendant's testimony since he did not testify. And included the paragraph on defendant not testifying, and including the paragraph regarding defendant's statements. Rules for deliberation is standard. I just found a little typo that I'll correct. There was a bracket still in there. And then let's talk about exhibits. Our cautionary instruction is standard, verdict is standard. Single defendant, multiple counts is standard.
Part of the section.
Seated. All right, let the record reflect the parties are again present. The defendant is present, the jury is not. Ready to proceed with instructions?
We just wanted to, we spoke to defend alternate jurors. Once you send these jurors back, obviously we're going to need them for the penalty phase. So we just wanted to make sure, remember to instruct them. Either some judges have sequestered them, like put them in another courtroom. Others have just sent them home and told them not to talk about the
My
case.
intent would be to send them home, tell them not to communicate with anyone about the case, and that they will receive word from us about whether they're needed for phase 2.
Thank you, Judge.
Anything else then? All right, let's go ahead and bring the jury back in. Start from the
All rise as the jurors enter the courtroom, please.
Thank you. Please be seated. Members of the jury, on your chair beside your notes, you'll find a copy of the instructions that I'm about to read to you. We provide you with a written copy. Everybody learns differently. Some like to listen, some like to read, some like to do both. It's your option. Please be informed that as I read the instructions, occasionally I find something and I make a correction as I say it. What I say is what's on the record, and the official copy, which is up here, is what we'll be taking back to deliberate. Members of the jury, I want to thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Mark Howard Wilson Jr., the defendant in this case, is accused in the indictment with 2 counts of first-degree murder, 1 count of burglary with an assault or battery, and 1 count of burglary while armed. In counts 1 and 2 of the indictment, Mark Howard Wilson Jr. is accused, respectively, of the first-degree murder of Robert Baker and Tatum Baker. Each of these counts of first-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. If in count 1 you find that Robert Baker was killed by Mark Howard Wilson Jr., you'll then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Likewise, in count 2, if you find that Tatum Baker was killed by Mark Howard Wilson Jr., you'll then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The following instructions concerning excusable and justifiable homicide apply to both counts 1 and 2 of the indictment. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. One, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or three, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Mark Howard Wilson Jr. may be found guilty of first-degree murder as charged in count one of the indictment or any lesser included crime. Count one of the indictment, first-degree murder, Robert Baker. There are two ways in which a person may be convicted of first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. First-degree premeditated murder. To prove the crime of first-degree premeditated murder, as charged in count one of the indictment, the state must prove the following three elements beyond a reasonable doubt. One, Robert Baker is dead. Two, the death was caused by the criminal act of Mark Howard Wilson Jr. Three, there was a premeditated killing of Robert Baker. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. First-degree felony murder. To prove the crime of first-degree felony murder as charged in count one of the indictment, the state must prove the following three elements beyond a reasonable doubt. One, Robert Baker is dead. Two, while engaged in the commission or attempted commission of a burglary, Mark Howard Wilson Jr. caused the death of Robert Baker. Three, Mark Howard Wilson Jr. was the person who actually killed Robert Baker. In order to convict of first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. The court will now instruct you concerning the definition of burglary as it applies to the crime of first-degree felony murder as charged in count one of the indictment. Burglary. To prove the crime of burglary as it relates to the second element of first-degree felony murder in count one of the indictment, the state must prove the following two elements beyond a reasonable doubt. One, Mark Howard Wilson Jr. had permission or consent to enter a structure owned by or in the possession of Chad and Sarah Baker. Two, Mark Howard Wilson Jr., after entering the structure, remained therein with the intent to commit or attempt to commit an aggravated assault or aggravated battery or manslaughter or second degree or first degree murder inside the structure. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an aggravated assault or aggravated battery or manslaughter or second degree murder or first degree murder, the defendant must be found not guilty of burglary for the purposes of finding the second element of first degree felony murder. Structure means any building of any kind, either temporary or permanent, that has a roof over it, and the enclosed space of ground and outbuildings immediately surrounding that structure. The second element of burglary further requires that you make a determination or finding that Mark Howard Wilson Jr. intended to commit either aggravated assault or aggravated battery or manslaughter or second degree murder or first degree premeditated murder. And I'll now define those crimes for you for the purpose of that element. Aggravated assault. The offense of aggravated assault contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit aggravated assault at the time of the burglary. The first three elements define assault. 1, Mark Howard Wilson intentionally and unlawfully threatened, either by word or act, to do violence to Robert Baker. 2, at the time, Mark Howard Wilson Jr. appeared to have the ability to carry out that threat. 3, the act of Mark Howard Wilson Jr. created in the mind of Robert Baker a well-founded fear that the violence was about to take place. 4, the assault was made with a deadly weapon. If the circumstances were such to ordinarily induce a well-founded fear in the mind of a reasonable person, then the victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. A deadly weapon is any object that will cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Now, great bodily harm is defined for you above at page 4. You should continue to use that definition here as well. Aggravated battery. The offense of aggravated battery contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit aggravated battery at the time of the burglary. The first element is the definition of battery. 1, Mark Howard Wilson Jr. actually and intentionally touched or struck Robert Baker against his will. 2, Mark Howard Wilson Jr. in committing the battery either A, intentionally or knowingly caused great bodily harm to Robert Baker, or B, used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Manslaughter. The offense of manslaughter contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit manslaughter at the time of the burglary. 1, Robert Baker is dead, and 2, either A, Mark Howard Wilson Jr. intentionally committed an act or acts that caused the death of Robert Baker, or B, the death of Robert Baker was caused by the culpable negligence of Mark Howard Wilson Jr. The defendant cannot be guilty of manslaughter by committing a mere negligent act, or if the killing was either justifiable or excusable homicide, as I had previously instructed you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to do harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Culpable negligence. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Second-degree murder. The offense of second-degree murder contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit second-degree murder at the time of the burglary. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Robert Baker is dead. 2, the death was caused by the criminal act of Mark Howard Wilson Jr. 3, there was an unlawful killing of Robert Baker by an act imminently dangerous to another or demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. First-degree premeditated murder. The offense of first-degree premeditated murder contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is to determine whether the defendant actually intended to commit first-degree premeditated murder upon Robert Baker at the time of the burglary. The definition of premeditated first-degree murder has previously been defined for you on page 4. You should refer to that definition above and use it here as well. Now, lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of first-degree murder as charged in count 1 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you'll next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of first-degree murder as charged in count 1 of the indictment are second-degree murder and manslaughter. To prove the lesser included crime of second-degree murder as it relates to count 1 of the indictment, the state must prove the following three elements beyond a reasonable doubt. 1, Robert Baker is dead. 2, the death was caused by the criminal act of Mark Howard Wilson Jr. 3, there was an unlawful killing of Robert Baker by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Mark Howard Wilson Jr. committed second-degree murder, and you are also find beyond a reasonable doubt that during the commission of the crime, he personally carried or displayed or used or threatened to use or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Mark Howard Wilson Jr. committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried or displayed, or used or threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter. To prove the lesser included crime of manslaughter as it relates to count 1 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, Robert Baker is dead, and 2, either A, Mark Howard Wilson Jr. intentionally committed an act or acts that caused the death of Robert Baker, or B, the death of Robert Baker was caused by the culpable negligence of Mark Howard Wilson Jr. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Culpable negligence has been defined for you above on page 10. You should use that definition here as well. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. If you find that Mark Howard Wilson Jr. committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried or displayed or used or threatened to use or attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon has been defined for you above on page 15. You should use that definition here as well. If you find that Mark Howard Wilson Jr. committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried or displayed or used or threatened to use or attempted to use a weapon, then you should find him guilty only of manslaughter. Count 2 of the indictment, first-degree murder, Tatum Baker. There are two ways in which a person may be convicted of first-degree murder. One is known as first-degree premeditated murder. The other is first-degree felony murder. First-degree premeditated murder. To prove the crime of first-degree premeditated murder as charged in count 2 of the indictment, the state must prove the following three elements beyond reasonable doubt. 1, Tatum Baker is dead. 2, the death was caused by the criminal act of Mark Howard Wilson Jr. And 3, there was a premeditated killing of Tatum Baker. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. First-degree felony murder. To prove the crime of first-degree felony murder as charged in count 2 of the indictment, the state must prove the following three elements beyond a reasonable doubt. Tatum Baker is dead. 2, while engaged in the commission or attempted commission of a burglary, Mark Howard Wilson Jr. caused the death of Tatum Baker. 3, Mark Howard Wilson Jr. was the person who actually killed Tatum Baker. In order to convict of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. The court will now instruct you concerning the definition of burglary as it applies to the crime of first-degree felony murder as charged in count 1 of the indictment. Burglary. To prove the crime of burglary as it relates to the second element of first-degree murder in count 2 of the indictment, and that is count 2 that we're referring to. The state must prove the following three elements beyond a reasonable doubt. 1, that Mark Howard Wilson Jr. had permission or consent to enter a structure owned by or in possession of Chad and Sarah Baker. 2, Mark Howard Wilson Jr., after entering the structure, remained therein with the intent to commit or attempt to commit an aggravated assault or aggravated battery or manslaughter or second-degree murder or premeditated first-degree murder inside the structure. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case. Even though an unlawful remaining in the structure is proved, if the evidence does not establish that it was done with the intent to commit an aggravated assault or aggravated battery or manslaughter or second-degree murder or first-degree premeditated murder, the defendant must be found not guilty of burglary for the purpose of finding the second element of first-degree felony murder. Structure means a building of any kind, either temporary or permanent, that has a roof over it, and the enclosed space of ground and outbuildings immediately surrounding that structure. The second element of burglary further requires that you make a determination or finding that Mark Howard Wilson Jr. intended to commit either aggravated assault or aggravated battery, or manslaughter, or second-degree murder, or first-degree premeditated murder. I'll now define those crimes for you for the purpose of that element. Aggravated assault. The offense of aggravated assault contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit aggravated assault at the time of the burglary. The first three elements define assault. 1, Mark Howard Wilson Jr. intentionally and unlawfully threatened, either by word or act, to do violence to Tate and Baker. 2, at the time Mark Howard Wilson Jr. appeared to have the ability to carry out the threat. 3, the act of Mark Howard Wilson Jr. created in the mind of Tate and Baker a well-founded fear that the violence was about to take place. And 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then the victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm has been defined for you above at page 4. You should use that definition here as well. Aggravated battery. The offense of aggravated battery contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit aggravated battery at the time of the burglary. The first element is a definition of battery. 1, Mark Howard Wilson Jr. actually and intentionally touched or struck Tate and Baker against his will. 2, Mark Howard Wilson Jr. in committing the battery either A, intentionally or knowingly caused great bodily harm to Tate and Baker, or B, used a deadly weapon. As above, a deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Manslaughter. The offense of manslaughter contains certain elements which, if it is charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit manslaughter at the time of the burglary. 1, Tate and Baker is dead. And 2, either A, Mark Howard Wilson Jr. intentionally committed an act or acts that caused the death of Tate and Baker, or B, the death of Tate and Baker was caused by the culpable negligence of Mark Howard Wilson Jr. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I had previously instructed you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Culpable negligence has been defined for you at page 10. You should apply that definition here as well. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Second-degree murder. The offense of second-degree murder contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit second-degree murder at the time of the burglary. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tate and Baker is dead. 2, the death was caused by the criminal act of Mark Howard Wilson Jr. 3, There was an unlawful killing of Tate and Baker by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and two, is done from ill will, hatred, spite, or an evil intent, and three, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. First-degree premeditated murder. The offense of first-degree premeditated murder contains certain elements which, if charged as a separate crime, the state would have to prove beyond a reasonable doubt. Your analysis here is whether the defendant actually intended to commit first-degree premeditated murder upon Tate and Baker at the time of the burglary. The definition of premeditated first-degree murder has been previously defined for you on page 17 with regard to Tate and Baker. You should refer to that definition above and use it here as well. Lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of first-degree murder as charged in count 2 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of first-degree murder as charged in count 2 of the indictment are second-degree murder and manslaughter. Second-degree murder. To prove the lesser included crime of second-degree murder as it relates to count 2 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1. Tate and Baker is dead. 2. The death was caused by the criminal act of Mark Howard Wilson Jr. 3. There was an unlawful killing of Tate and Baker by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Mark Howard Wilson Jr. committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried or displayed or used or threatened to use or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. Weapon has been defined above for you on page 15. You should use that definition here as well. If you find that Mark Howard Wilson Jr. committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried or displayed or used or threatened to use or attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter. To prove the lesser included crime of manslaughter as it relates to count 2 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tate and Baker is dead. 2, either A, Mark Howard Wilson Jr. intentionally committed an act or acts that caused the death of Tate and Baker, or B, the death of Tate and Baker was caused by the culpable negligence of Mark Howard Wilson Jr. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Culpable negligence has been defined for you above on page 10. You should use that definition here as well. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, or reasonably should have known, was likely to cause death or great bodily harm. If you find that Mark Howard Wilson Jr. committed manslaughter, and you also find, beyond a reasonable doubt, that during the commission of the crime, he personally carried or displayed or used or threatened to use or attempted to use a weapon, you should find him guilty of manslaughter with a weapon. Weapon has been defined for you above on page 15. You should use that definition here as well. If you find that Mark Howard Wilson Jr. committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried or displayed or used or threatened to use or attempted to use a weapon, then you should find him guilty only of manslaughter. Count 3 of the indictment, burglary with assault or battery. I now instruct you on the circumstances that must be proved before Mark Howard Wilson Jr. may be found guilty of burglary with assault or battery, as charged in count 3 of the indictment, or any lesser included crime. To prove the crime of burglary with assault or battery as charged in count 3 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. To prove the crime of burglary, the state must prove the following 2 elements beyond a reasonable doubt. I'm sorry. To prove the crime of burglary, the state must prove the following 2 elements beyond a reasonable doubt. Mark Howard Wilson Jr. had permission or consent to enter a structure owned by or in the possession of Chad and or Sarah Baker. 2, Mark Howard Wilson Jr., after entering the structure, remained therein with the intent to commit or attempt to commit an aggravated assault or aggravated battery or manslaughter or second-degree murder or first-degree premeditated murder inside the structure. The definitions of aggravated assault, aggravated battery, manslaughter, second-degree murder, or first-degree premeditated murder have previously been defined for you. You should apply them here as well. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case. Even though an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit aggravated assault or aggravated battery or manslaughter or second-degree murder or first-degree premeditated murder, the defendant must be found not guilty of the burglary. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find Mark Howard Wilson Jr. guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether in the course of committing the burglary, Mark Howard Wilson Jr. assaulted any person. An assault is an intentional and unlawful threat, either by word or act, to do violence to another at the time when the defendant appeared to have the ability to carry out the threat, and his act created a well-founded fear in the other person that the violence was about to take place. If you find Mark Howard Wilson Jr. guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing the burglary, Mark Howard Wilson battered any person. A battery is an actual and intentional touching or striking of another person against that person's will, or the intentional causing of bodily harm to another person. If you find Mark Howard Wilson Jr. guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. For purposes of burglary, a dwelling includes an attached porch or attached garage. lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of burglary with assault or battery, as charged in count 3 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crime indicated in the definition of burglary with assault or battery, as charged in count 3 in the indictment, is trespass while armed. Trespass. To prove the crime of trespass in a structure, the state must prove the following 3 elements beyond a reasonable doubt. 1. Mark Howard Wilson Jr. willfully entered or remained in a structure. 2. The structure was the lawful possession of Chad and Sarah Baker. 3. Mark Howard Wilson Jr.'s entering or remaining in the structure was without authorization, license, or invitation by Chad and Sarah Baker or any other person authorized to give that permission. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if, under all the circumstances, a reasonable person would believe that he had the permission of the owner, lawful occupant, or any other person authorized to give that permission. Person authorized means an owner or lessee, or his or her agent, or any law enforcement officer whose department has received written authorization from the owner or lessee, or his or her agent, to communicate an order to depart the property in case of a threat to public safety or welfare. Willfully means intentionally, knowing, and purposefully. Structure has been defined for you above on page 7. You should use that definition here. If you find the defendant guilty of trespass in a structure, you must then determine whether the state has proved beyond a reasonable doubt that there was a human being in the structure at the time of the trespass. Count 4 of the indictment, burglary while armed. I now instruct you on the circumstances that must be proved before Mark Howard Wilson Jr. may be found guilty of burglary while armed as charged in count 4 of the indictment or any lesser included crime. To prove the crime of burglary while armed as charged in count 4 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. To prove the crime of burglary, the state must prove the following 2 elements. 1. Mark Howard Wilson Jr. had permission or consent to enter a structure owned by or in the possession of Chad and or Sarah Baker. 2. Mark Howard Wilson Jr. after entering the structure remained therein with an intent to commit or attempt to commit an aggravated assault or aggravated battery or manslaughter or second-degree murder or first-degree premeditated murder inside the structure. The definitions of aggravated assault, aggravated battery, manslaughter, second-degree murder, and first-degree premeditated murder have previously been defined for you. You should apply them here as well. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit aggravated assault, or aggravated battery or manslaughter, or second-degree murder, or first-degree premeditated murder, the defendant must be found not guilty of burglary. Structure has been defined for you above on page 7. You should continue to use that definition here as well. If you find Mark Howard Wilson Jr. guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing the burglary, Mark Howard Wilson Jr. was armed or armed himself within the structure with a dangerous weapon. For an object that was designed or constructed to cause death or great bodily harm if used in its ordinary and usual manner, it is not necessary for the state to prove the defendant was willing to use the object in furtherance of the burglary in order for the object to constitute a dangerous weapon. An object is not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm has been defined for you above on page 4. You should use that definition here as well. If you find Mark Howard Wilson Jr. guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. Dwelling has been defined for you above on page 31. You should use that definition here as well. Lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of burglary while armed as charged in count 4 of the indictment, There may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crime indicated in the definition of burglary while armed as charged in count 4 of the indictment is trespass while armed. Trespass while armed. To prove the crime of trespass in a structure, the state must prove the following 3 elements beyond a reasonable doubt. 1, Mark Howard Wilson Jr. willfully entered or remained in the structure. 2, the structure was in the lawful possession of Chad and or Sarah Baker. 3, Mark Howard Wilson Jr.'s entering or remaining in the structure was without authorization, license, or invitation by Chad and Sarah Baker, or any other person authorized to give that permission. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in the structure of another if under all the circumstances a reasonable person would believe that he had the permission of the owner, lawful occupant, or any other person authorized to give that permission. Person authorized means an owner or lessee, or his or her agent, or any law enforcement officer whose department has received written authorization from the owner or lessee, or his or her agent, to communicate an order to depart the property in case of a threat to public safety or welfare. Willfully means intentionally, knowingly, and purposefully. Structure has been defined above on page 7. You should continue to use that definition here. If you find the defendant guilty of trespass in a structure, you must then determine whether the state proved beyond a reasonable doubt that the defendant was armed or armed himself with a dangerous weapon during the trespass. If you find the defendant guilty of trespass in a structure, you must also determine whether the state proved beyond a reasonable doubt that there was a human being in the structure at the time of the trespass. Dangerous weapon has been defined for you on page 4. You should use that definition here as well. For an object that was designed or constructed to cause death or great bodily harm if used in its ordinary and usual manner, it is not necessary for the state to prove that the defendant was willing to use the object in furtherance of the trespass in order for an object to constitute a dangerous weapon. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it is used in a manner likely to cause death or great bodily harm. Again, great bodily harm has been defined for you on page 4. You should continue to use that definition as well. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. That means you must presume or believe that the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information and the indictment throughout each stage of the trial, unless it has been overcome by evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence there is not an abiding conviction of guilt, or if having a conviction is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some time, other time, make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for the lawyers to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of evidence or testimony of any witness. Defendant not testifying. The Constitution requires the state prove its accusations against the defendant. It's not necessary for the defendant to disprove anything. Nor is the defendant required to prove his innocence. It's up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain that it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, he'd been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It's the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. They are as follows. You don't have them there. I'll show them to you here. Page 1 has the case styling on it. Verdict, count 1. We, the jury, find the defendant, Mark Howard Wilson, Jr., as follows, as to count 1 of the indictment. There's a series of lines down the left side of the page here. It notes up here, please choose only one as to count 1. The first option is guilty as charged of both first-degree premeditated murder and first-degree felony murder, contrary to Florida statutes. Second, guilty as charged of only first-degree premeditated murder, contrary to Florida statutes. Third, guilty as charged only of first-degree felony murder, contrary to Florida statutes. Fourth option, guilty of the lesser included crime of second-degree murder contrary to Florida statutes. If and only if you make a finding on that count, you would answer, if you find the defendant guilty of second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense the defendant used a weapon, yes or no? You only answer that if your verdict was the lesser included of second-degree murder. Fifth option, guilty of the lesser included crime of manslaughter contrary to Florida statutes. There is also an interrogatory. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense the defendant used a weapon, yes or no, or not guilty? Page 2, verdict count 2. It mirrors what you saw on page 1. Please choose only one as to count 2. Guilty as charged of both first-degree premeditated murder and first-degree felony murder contrary to Florida statutes. Guilty as charged only of first-degree premeditated murder contrary to Florida statutes. Guilty as charged of only first-degree felony murder contrary to Florida statutes. Guilty of the lesser included crime of second-degree murder contrary to Florida statutes with the same interrogatory. If you find the defendant guilty of second-degree murder, do you also find beyond a reasonable doubt that during the commission of the offense the defendant used a weapon, yes or no? Guilty of the lesser included crime of manslaughter, same interrogatory. If you find the defendant guilty of manslaughter, do you also find beyond a reasonable doubt that during the commission of the offense the defendant used a weapon, yes or no, or not guilty? Count 3. Choose one as to count 3. Guilty as charged of the crime of burglary. If you find the defendant guilty of burglary, do you also find beyond a reasonable doubt any of the following circumstances? Please answer yes or no to each of the following. The structure entered was a dwelling, yes or no. During the commission of the burglary, the defendant committed an assault or battery upon Tatum Baker or Robert Baker, yes or no. Guilty of the lesser included crime of trespass in a structure contrary to Florida statutes. If you find the defendant guilty of trespass in a structure, do you also find beyond a reasonable doubt any of the following circumstances? Answer yes or no. While the defendant was in the structure, the defendant was occupied by another human being, yes or no, or not guilty. Count 4, verdict. We, the jury, find the defendant, Mark Howard Wilson, as follows. As to count 4 of the indictment, please choose only one. Guilty as charged of the crime of burglary, contrary to Florida statutes. If you find him guilty of that, then answer the following interrogatories, yes or no. If you find the defendant guilty of burglary, do you also find beyond a reasonable doubt the following circumstance? The structure entered was a dwelling, yes or no. If you find the defendant guilty of burglary, do you also find beyond a reasonable doubt that during the commission of the offense the defendant used a weapon, yes or no? Guilty of the lesser included crime of trespass in a structure contrary to Florida statutes. Please answer yes or no to the following. If you find the defendant guilty of trespass in a structure, do you also find beyond a reasonable doubt any of the following circumstances? First, while in the structure the defendant was armed with a weapon, yes or no? While the defendant was in the structure was occupied by another human being, yes or no, or not guilty. On the final page of the verdict form is a place for the foreperson to date and sign, and it is so say we all. At this time, we're going to hear the closing arguments by the attorneys. The parties will receive equal time for the closing arguments. The state is entitled to divide their time between an opening and a rebuttal argument after the defense has made their closing argument. State, you're ready to proceed?
Yes, Your Honor. Thank you. May I please report, counsel?
Please.
Ladies of the jury. Robert and Tatum Baker, 2 young boys with such a long life ahead of them to live. And the evidence in this case has shown no proof that there is any reason to justifiably kill or commit excusable homicide on these two boys. No reason to justify or excuse brutally beating them to death with a hammer and slitting their throats with a knife. None. They did nothing on the morning of August 26, 2020 to provoke this defendant to enter the house and kill them. He didn't get provoked by finding them with his wife. He didn't get provoked by finding them abusing his child. None of that. There's no evidence that any of that was even happening. What was going on? They were sleeping in their home that morning. The evidence at the scene supports that. They were found laying where they always went to sleep in those initial days in that home next to where their cell phones could charge. And we know they were sleeping because this man, the defendant, told detectives, I went in there. They were sleeping. They did nothing, ladies and gentlemen. And the judge just went through a lot of law with you guys, obviously. And so there's an instruction in all of that he read to you that tells you that when you consider each count, you're to start at the top and you're to analyze the evidence for the highest charge alleged and then go through the lesser included. So I'm going to spend my time this morning because the state believes, or this afternoon, the state believes that the evidence is overwhelmingly in support as charged. And so I'm going to focus on that with you. And you know, we talked in jury selection, and you learned that there's more than one way to commit first-degree murder, and you've now heard those instructions. And the state's obviously going under both theories in this case, okay? And so first we'll talk about premeditation and what that means, where that evidence comes from in this case, and then we'll talk about the felony murder, okay? And you heard the three elements. I don't expect those first two elements to be in dispute in this case, either to count one or count two, okay? So we're gonna focus now and talk about why there was a premeditated killing of both Robert and Tayton Baker under the law. And again, I know the judge read this sort of at the beginning, but just remember, and you remember whether I selected you last week during the jury or Mr. Lewis, but both of us gave examples of premeditation. And you remember when we went through with you and we talked about the fact that even just somebody quickly, within seconds, going and obtaining a weapon and committing a crime that was done and over and thought of in seconds could be premeditation, okay? And you guys had that definition. Well, we have far beyond that in this case, and I want to talk about that with you. Much like most crimes, the premeditation in this case begins obviously with thoughts. It's very clear now that the trial and evidence has ended that this defendant thought about killing these boys. Now, why? You've now heard several things, and we're going to go over that. But clearly, he had thoughts of killing them for whatever reason, right? He gave many reasons. I was protecting my family is the overall reason, but thoughts of killing them, whether it's because he thought his family was going to be turned in, whether he thought they were doing something to his kid, his wife, whatever it is, it began with thoughts. And we have that in this case. We know while he was thinking about it, and he had these thoughts, and he's struggling with thoughts, what did he do in the early morning hours of August 26th? He wrote a letter to Cindy. And I want to point out a few things from that letter. You get a little bit of whatever feelings he was going through in the early morning hours. He's frustrated. He's upset. And he says to her, and this last line, one of the last lines is important if you look at the tense. Please promise me that she will always know that her dada is a soldier, talking about his daughter, and that he loved you both from day one. Why would he need to write Cindy that letter if he wasn't going to be around and if he wasn't going to be able to tell his little girl himself how much he loved her? There's been no evidence that they were fighting and breaking up. And no, he told the detectives in the interview they were just about to go get their water and power turned back on and move back in together. How much he loved his family. Now that's the reason and the excuse that it took him a minute to come up with in the interview room as to what he meant by that letter. But that letter was written the night or the early mornings before this happened. Why? Why do you say that? Unless you need someone else to ensure that your daughter knows that you loved her because you're not going to be around. So he's putting his thoughts in writing. And then, of course, we know in this case, once the decision has been made to do it, now we've had time to reflect already. We've thought about it. We've written a letter contemplating not being around. Now we're going to arm ourselves with 2 weapons. And the 2-weapon thing is important for a couple reasons. But I want to touch on the other thing, and you may have picked up that the state pointed out a few times that in the game room outbuilding, there was a Glock, a gun box. It was pretty obvious. It sat on the corner of a desk and ammunition on top of that, okay? And we pointed that out, and you heard the testimony from Sarah Baker that the night before this, they were in that game room putting the shelves up and all of Chad's figurines, and they were trying to surprise him when he came back home. So we know Mark Wilson was in that room. We know that he likely saw that gun, and that's an option. Why didn't he take the gun? The gun still would have made it premeditated murder, but I think it's important to note what he chose. He chose 2 weapons. He chose weapons that would not necessarily make it a quick murder. A gun would have been a quicker way to kill those boys. He chose a hammer to beat them with, a knife to slit their throats if he needed to. He found 2 items. That takes time. He then entered, and while killing each of the boys, which we'll talk about, he switches weapons. He beats each of them and then switches to slitting their throats. Every step of the way, there's opportunities to stop and reflect, realize what you're doing, and not continue. And so, of course, we know those are the weapons. And so after he arms himself, he obviously walks. He walks from wherever he is on the property, his house, the other outbuilding, and enters that house. It's steps. It's not a mile. But again, there's nothing in the law that tells you that someone has to think about it for 10 minutes, walk a mile to change their mind. He has time to change his mind. He enters the house after walking from somewhere else on the property. Now I want to talk about the circumstances of the actual killing. All of this has already occurred. And then he makes the decision to enter the home, right? And when you talk about the crimes of each boy, I want to start with Robert. And I'm going to explain to you a little bit later in more detail. Even though the defendant states in his statement that he killed Tayton first, I'm going to talk to you later about why I believe that's not consistent with some of the evidence. And we may touch on it here as well. Robert, remember his injuries. He has a large neck injury and 5 other stabbing injuries. And these photos are awful, but I think you now understand why the state has to show you these things, has to show you details, because remember what Dr. Fulcher said. That's not one slice to the neck. All of those little slices down there below show multiple, bringing out of a blade and making the choice to do it again. And then obviously you have all of the superficial wounds in addition to that. Robert has at least 4 blunt force injuries. He had a blunt force on his chin. He had 2 over his left ear, which caused that photograph that you saw with the back of his skull cracked open. And he has the blunt force on the forehead and to the top of the head, which you saw that perfectly punched out circle, skull fracture, brain damage by the one near the ear. That takes a lot of force. Every time you beat someone with a hammer and you slice someone with a knife, that's time. That's time. And then what does he do? He covers Robert up. He covers Robert up. And then, of course, we have Tayton. Tayton has similar injuries, although a lot more, and a lot more going on with Tayton that you saw in the pictures and the scene. he has approximately 15 to 20. I'm just going to approximate. You guys rely on your notes from that. But we obviously have the 3 very large injuries. But remember what Dr. Fulcher said, every single small superficial injury on that case shows an attempt to keep slicing his neck. And then what else with Tayton? We have at least, well, let's count them. Let's count the blunt force injuries. We have the one under his lip. What did Dr. Fulcher tell you? And he explained why that's not something that he got hit in the face. He didn't get hit in the face. Why? Because you would clearly see an injury out here, and there was no injury. You saw the face photo of him in the beginning of the autopsy, and you don't see the injury there. So that is him laying down on the ground, being beat in the back of his head, causing so much force that laying on the carpet causes that injury. And then, of course, you have, kind of starting on the left side of his head, you have 1, 2, and 3 blunt force, 4 and 5, 6 and 7, right there. Every blow takes time. And there's a chance to stop and reflect. And obviously, between the 2 boys, you have 2 different victims in 2 different locations, still feet away. But it's time, oh my God, what did I do? And not go on and kill the other. But that's not what happened here. And with Tayton, to further illustrate the struggle, the time that this crime would have taken, and the fact that he was faced with fighting or a confrontation with Tayton, instead of just killing somebody in their sleep, and they have no time to react and maybe cause somebody to stop. What do we have with Tayton? We have defensive wounds, and we have him crawling away, ladies and gentlemen. All of these things, you play it out, how this could have possibly happened, and it shows how much time this crime occurred. That takes time. That blood trail takes time. And we know, because he's also covered up with a blanket, we know his bloody palm print is on the wall, inches from his phone, a foot or so away from where he eventually lay. We know that palm print had to have gotten there while Mark Wilson was still there, struggling with him and fighting with him, because how does Sarah find her son Tayton? Right, covered with a blanket, right where he lay when FDLE got there to photograph him. So that struggle that he didn't remember, that he didn't want to talk about, do you remember that from the interview? It was towards the very end when Detective Usina asked him about Robert. He was able to just kind of answer the questions. Yes, head, neck, that's how I did it. But when he asked about Tayton, I don't know. What about him crawling? I don't know. He didn't want to talk about it because it's horrific. He didn't want to talk about that. You don't forget that. And all of that shows the lengthy premeditation and all of his opportunities to stop. And again, he covers them with a blanket, like I said. And ladies and gentlemen, that summarizes everything that proves premeditation in this case beyond the exclusion to every reasonable doubt for both boys, for counts 1 and 2 under that theory. But we also have submitted to you that he's guilty under the felony murder theory as well. Okay, and I know, again, you just heard it from the judge, but essentially it means that both boys are dead. I'm kind of going to talk about them together. Both boys are dead, but he was a person that killed them, which we know that. The defense, and I expect it to continue, has essentially conceded that he's the one that did this. This is not a who done it. So element 2, that the defendant killed the boys while engaged in the commission or an attempted commission of a burglary. Okay? The judge has explained it to you. And there's only 2 elements to burglary. And if you remember again in jury selection, when Mr. Lewis and/or I talked to you about burglary, and you probably walked in last week like thinking of the typical burglary. Somebody breaks into your house, steals your TV, or you're there, unfortunately, when that happens. But I think it was a surprise to a lot of people when we said, well, there's this other way. You can get invited in and be a guest, and then if you commit a forcible felony or violence against the homeowner who gave you permission, that turns that into a burglary, because you would not want that to happen, and you would be revoking your consent right there. And everybody's like, oh yeah, that makes a lot of sense, and it makes sense why the legislature would do that. So that is the other theory we have here. And we know that he had permission to be on that property, that Sarah and Chad Baker were helping him and Cindy out. He had permission to be living in the outbuilding and coming and going while he was in that house. And when he was on the property, clearly when he thought about doing this, and he formed the intent to kill those boys and did all the things we just discussed and went in to do it. So felony murder in addition to premeditated murder. Now, something else we talked about in jury selection, is the why. And we don't have to prove the why, like you guys learned and you've now been instructed by the judge, but obviously the why, the reasons why somebody may do that, they do play an important role, especially in this case, in thinking about his premeditation, because you want to know, what was he thinking, right? What did he say? How long had he been thinking about it? And things like that. So I want to go through with you, what do we know about all of the reasons why this may have been done. And first, I want to start with the first indication of why. And that was when his mom, Cindy Atkins, did the right thing. Her son came and told her, or she kind of confronted him about cooperating, and he told her he did it and why. And so she agreed to help law enforcement with that. And so I want to play for you just one clip from that car ride.
Like I said. That's what she was supposed to do the first half, which meant her sister and the little boy, and he was supposed to do the other two boys. What the fuck?
And then later in the conversation, it's interesting because he tells his mom that. I think it's important. He tells his mom that when he doesn't know he's being recorded. And she asks him, are you doing this because of Cindy and Caitlin, which is, of course, all the reasons why he tells law enforcement, and he says no.
I know you felt unsafe because of Andy. But you're saying it's because of Cindy and Caitlin why you hurt these two boys. No, I don't understand that.
Right, his mom doesn't even, there's no reason, I don't believe a reason that would ever make sense in this case. But his mom doesn't understand this. Law enforcement clearly didn't understand, and they were giving him reasons and asking him why. And I want to go through just some of those to show you all of the different things he threw out. One of the things he said in the very beginning, and you might have missed it because he never brings it up again, but the very first reason he gives law enforcement, when they asked, is she alienating you? He's like, yeah, from my mom and my uncle. I mean, that he threw that out in the very beginning. It's never mentioned again. And then later, I believe that they're abusing my daughter, and we're going to talk more about that in a minute. I believe Cindy is sleeping with the boys. I'm protecting my family, which was sort of the overarching theme of his entire interview with law enforcement. Another reason he threw out at one point, if you missed it, was, they're just imploring with him, help us make this make sense. And he just says, Caitlin got a busted lip. And I think Detective Sino was like, did the boys do it? Like, what, he's trying to understand. And he's like, no, but it happened here on the property. He's not sure how it happened, but that's apparently a reason. And Cindy was, of course, just amping him up. Cindy was just amping him up, but ultimately he tells law enforcement, but Cindy didn't directly tell me to do it, I just thought I was supposed to do it. None of it makes sense, ladies and gentlemen. None of it makes sense. And in this interview, when you kind of think about the statements he makes to his mom when doesn't know he's being recorded versus statements he makes to law enforcement after hours and hours and hours, I just want you to think about that. And think about whether he told the truth or not in this interview. And of course, we know he starts it off denying for several hours, right? He denies for several hours. He's shown that letter that he wrote. And if you were paying attention to his response when they showed him that letter, it wasn't like, oh yeah, I wrote this morning, an immediate, I know what this is. I was going to the store to buy eggs and I left this for my girlfriend. He read the letter. He read the whole letter. And they're asking him, why'd you write this? Why'd you write this? He stalled, and then eventually again came up with the excuse that he thought him and Cindy were breaking up. Even in the interview after confronted with the audio evidence between him and his mom, what does he still say right after? I didn't do it. I mean, he's just lying and lying and lying and lying. He's not credible. And then the daughter. His daughter was being sexually abused by the boys. He throws, and if you were watching the interview, and I followed up with Detective Usina is throwing out. Remember he told you, like, I do this, I try to see if there are reasons. He wasn't exactly talking a lot to him, right, Mark Wilson? So he's throwing out different things. Could it be this? Could it be this? And he agrees with him when he gets to that part. But what did Detective Usina tell you? Obviously, after that interview, they wanted to look into that and investigate that further. They sent Caitlin for a child protective team forensic medical examination. There's no evidence that that child was sexually molested. And then again, he tries to blame Cindy for all or part of it during his interview with little to no details. You know, and then at one point it's Cindy just helped clean up. Cindy knew, she didn't tell me, she made me think to do it, but she cleaned up. And so they're asking him, what did she do? What did she do to help clean up? Because you're saying you don't know how these weapons got back there. And one of the things that he says that Cindy did to help him was that Cindy creates this doctor's appointment and the idea to go to it as an alibi. That's how he's trying to essentially throw her under the bus in this interview, right? Well, what do we know? That's not true. Sarah Baker testified that the night before, she was asked to give them gas money to go to this doctor's appointment. She knew Cindy was pregnant. She knew she had to go get WIC benefits. She left $10 on the table. The $10 found under the body of Tayton Baker with blood on it, hence why they didn't have their $10 when they left and they had to go and see Debbie. That was a planned doctor's appointment. He's throwing Cindy under the bus in this interview. Also, Debbie testified. She knew about that meeting. That was no surprise when they called and asked for gas money, or excuse me, the doctor's appointment. That was something the family knew was happening the next morning. That wasn't something that Cindy created that morning to cover for him. And then he mentions in the interview drugs and being up. Again, I want to just point out to that effect, there's no evidence of real impairment. There's no evidence of extreme impairment in this case. Think about a lot of that first part of the interview of the hours and hours of him lying and detectives trying to get all the details out for follow-up. How much driving did Mark Wilson do that morning? He drove a lot. He drove to the store. He drove them out to the appointment. He drove to their old house to check on his dog. He drove to the scene. And then when he got to the scene, Detective Higginbotham told you, and you heard him with your own ears in that interview. Did he sound upset? Sure, he didn't sound impaired. And Detective Higginbotham was like, I didn't notice anything that would have caused me any alarm, okay? And we have no evidence of impairment, extreme impairment in this case at all to blame any of this on. So I point all this out for you to judge his credibility of how honest or not was he being in that interview when he gave you reasons? Now, I want to talk to you about the DNA evidence, and it's obviously a lot of evidence and details we have to go through. So I've tried to summarize it here for you. And I mentioned earlier that the state believes the evidence supports Robert being killed first. There's a couple reasons for that. And one of the biggest reasons is DNA. Because what you're going to see as we go through this, whose DNA is overwhelmingly on everything? Tatum's. Robert is there, of course, on a few things. And sometimes when he's there, he's at a lot less DNA present than Tatum. But Tatum is on everything. And who is on the paper towels? Who is on the cleanup of the instruments? All of this. It's all Tatum. All of it is Tatum. And nobody else. Which would make sense if the last person you killed with the most bloody and violent scene was Tatum Baker. Okay? So I want to talk about that. And just to summarize each piece of evidence for you. Again, the hammer. Tatum. Okay? And I've put up here mostly references to the defendant, because you guys heard about all the other people. And when I say defendant not excluded, that is where they just don't have enough information. I'm not saying he's on there. What I'm saying is there's just not enough evidence. He's not excluded, okay? Knife, 1.2, Tatum on the blade, Tatum and Robert on the handle. On the sheath, Tatum +1. And so when I say +1, that's somebody who wasn't identified. If you remember when she talked about mixtures, she would say there's a mixture of 2, like with the hammer. There's a mixture of 2 on all of those. She's able to identify Tatum, not enough to say about anybody else, okay? So when I just say Tatum on stain A, that was a sole complete profile by Tatum. Stain B, Tatum and Robert. Stain C, Tatum and 1, defendant is not excluded. And then what is most important about the knife, again, Tatum and Mark Wilson on the handler portion of the knife. And I had her show you guys where she took those swabs from the top edges and bottom edge of the knife and the sheath that she pointed out to you. And then the placemats. A mixture on stain A. There are 2 people, Tatum and the defendant. The handler, which is the area trying to avoid the stains, Tatum, Robert. It's a mixture of 4, Tatum, Robert, 1 unknown, and Mark Wilson. And placemat 1.4, that second placemat, you've got Tatum and Mark Wilson, and then you have all of them on stain B, Tatum, Robert, and Mark, and of course, Cindy is present on that one as well, on the back. And then, as I said earlier, the paper towels, they're all Tatum except for the handler. And so when it meant the paper towels, she described how she had just, again, avoided the red-brown staining to try to see if there was any other touch DNA. And then the sweatshirt. The sweatshirt was located, if you remember the testimony, in that first bathroom down the hallway. The bathroom that a detective came in and told you that when he rounded that corner in the house clearing it, it smelled like fresh shower. It hit him, right? Mark Wilson obviously had to have a lot of blood on him from the scene. That's common sense. So this sweatshirt, which he was seen on video at the convenience store wearing that morning, Detective Usina asked him, it's the only thing they found. The shoes are missing still. The shorts were never found. He obviously had time to get rid of those things and came to the scene barefoot. Barefoot, if you remember that detail. This sweatshirt that he was in that morning was found in that bathroom where there's evidence of a fresh shower. And what was in it? What was in the pocket, according to Kelly Coco? Do you remember? Robert's phone. Robert's phone. And you saw in the crime scene photos, and Erin Morris testified that she showed you the phone cord and that there was no phone attached. So clearly the killer sweatshirt with the phone. And so stain A, it's Mark Wilson. And then obviously you have Tayton and Robert on the front. And Robert on the back of that sweatshirt. These verdicts forms, again, that the judge went over with you, they are a little confusing, so I just wanted to again point out what the judge was talking to you about and what we believe the evidence in this case supports. As we just went over, the state believes the evidence in this case, beyond and to the exclusion of a reasonable doubt, supports first-degree premeditated murder and felony murder as to both count 1 and count 2. And that's where you would check on there. If my clicker would work. And then on count 3, this one has a few more questions. Guilty as charged of burglary, we've discussed that. And then you answer the question whether the structure entered was a dwelling. That's defined for you. I think that's pretty straightforward. And then the second one is just during the commission of the burglary, did he commit an assault or a battery on Tayton or Robert, which are lessers of murder, and that answer is clearly yes. And then in count 4, it's a slightly different version of burglary. You have the burglary and the dwelling, and then this time the different question is just, did the defendant, you also find beyond a reasonable doubt that during the commission of the offense, he had a weapon with him, which clearly in this case he had 2. Ladies and gentlemen, home is where you feel safe. Home is where your kids are supposed to be safe. And this is why, when we talked about burglary, this is why not just breaking into someone's house and stealing a TV is burglary. This is why when you invite a guest into your home and they start committing violence against you, that invitation is revoked and you are now committing a burglary. And again, like I said, we talked about this in jury selection, and this is exactly what happened to these 2 little boys. They were killed in their homes where they were supposed to be safe by this man. They were beaten to death. Their throats were slashed. Each one of those injuries would have been fatal alone. There was no need to pick up a second weapon. He may not have known that, but we would have still been here. But he did, because he wanted to make sure they died. He wanted to make sure they died. And then, what did he do? He covered each one of them up with a blanket. He covered each one of them up with a blanket so their mother could come out and discover them brutally murdered in her home, a horror she will have to live with forever. Why did he do that? He did that, if you believe what he told his mother, he did that to protect his family. He wanted them to pay. He wanted them to hurt. The people that were trying to help him, who had bought him a vehicle, who knew that he and Cindy had a drug problem, who were just trying to help, but at the same time had rules, and you're not going to live in a house without water and power, and you're not going to smoke marijuana around that baby, and you're going to come live with me, and guess what? If you don't clean up your act, I might call DCF. That threatened him, that scared him, and it makes no sense to any of us, but he killed those boys to upset that family and somehow get revenge. Ladies and gentlemen, he is guilty beyond a reasonable doubt, as charged. There is no doubt, and we ask you to return those verdicts in this case. Thank you.
Defense, you ready?
protector, comforter, father and father figure. Just a few ways to describe Mark Wilson Jr. This is a tough case, there's no doubt about that. But it's also an unusual case. We have not gotten up here in front of you and said that Mark didn't do anything wrong. From the outset, we haven't hidden anything from you. So let's go through the evidence that was presented. You heard from Sarah Baker. She testified that she had recently moved to the 129 Shiloh address. She mentioned that Cindy and Mark had lived with her throughout time of them living in Lakeland. And once they moved here, Cindy and Mark's power was shut off, so she had them move in with her. She testified that Cindy and Mark had access to the house because where they were staying in the shed had no laundry, had no kitchen, and had no bathroom. So they were free to come and go between the house and their shed. She also testified, as the state said today, that on the 25th of August, Sarah, Cindy, and Mark were hanging shelves in the game room for Chad's collectibles. But Sarah also testified that she had a hard time sleeping because of her anxiety. So in the early morning hours, approximately 2 a.m., on August 26th, she went out her back door, which led to the porch, to smoke weed. She saw Mark out there, and she claimed that she saw Mark, and he seemed fine. Everything seemed normal, but he was out there sharpening a knife. And I asked her, were you interviewed by law enforcement on the 26th? And she said yes. And I said, did you tell law enforcement about that knife? No. And then I asked her, we deposed you on July 14th of this year, almost 2 years later. You were placed under oath. Do you remember telling us that he was out there sharpening a knife? She said she wasn't sure, and I showed her her deposition, and after reviewing her deposition, she said I didn't say that. I would submit to you that that's because it never happened. Sarah did not see Mark out there sharpening a knife that night. Now, Sarah also told you that it was not unusual for Cindy to borrow money from her, and in fact even wake her up to get money. And then you heard from a few deputies. They were kind of like the first responders, I guess. They went in, they cleared the house. And the first one would have been Deputy Valdivia. And he told you that the crime scene appeared to be a frenzy, and it was unorganized. And then you heard from Deputy French. He also was one of the first deputies to show up and cleared the house to make sure there was nobody else within the residence. He also said the same thing, that there was a lot of blood and that the crime scene seemed unorganized. And then you heard from Deputy Coyne. He also arrived on scene, was one of the ones that cleared the residence. I believe he was on the SWAT team at the time, along with being a detective. And he said, he agreed that it didn't appear there was any cleanup around the bodies. It was an unorganized scene. But Deputy Coyne also, that was his involvement for that day. On the 27th, he was back in the West District, I believe is what he said it was, Putnam County. And he receives information that Chrissy Atkins is at the police station with some information. So he interviews her, and Chrissy Atkins is Mr. Wilson's mom. And she tells him what happened that morning. And after a discussion, they decide to wire her and her vehicle to go and try and talk to Mark again. Now, Deputy Coyne told you that he was part of the takedown team. And when the call was made to stop the vehicle, he was one of the individuals that placed Mr. Wilson under arrest, and that Mr. Wilson didn't resist. And then you heard from Corporal Higginbotham, and he's the deputy, or the corporal, that came, I think at the time he was detective. He's the one who came in here and told you that he had 3 different interviews with Mr. Wilson on August 26th. And during each one of those interviews, Mr. Wilson was holding his daughter, and he said Mark mentioned that he wanted to spend as much time with her as he could. He also assisted with the search on the 27th, so he went back to the residence on the 27th and assisted with the search. And he was the deputy that located the knife and hammer underneath the sink in the game room. And you heard from Debbie Benson. She had received a call from Cindy that morning. She told you she didn't answer it. She was teaching her kids, homeschooling them. But Cindy kept calling and texting her to borrow money. She eventually answers the phone and agrees to give her $10. And you saw the video of her walking out to take the $10 to Cindy and coming back. You've heard from Erin Morris. She was the lady from FDLE, where the state entered all their photographs. She came out on the 26th to document the scene and collect evidence. And then she came out again on the 27th. But the decision was made, as she stated, by the Putnam County Sheriff's Office that they would do the hands of the search and she would document it. And so she was notified by the Sheriff's Office that they had located the hammer and the knife, wrapped in placemats underneath the sink in the game room. And you heard testimony from Chrissy Atkins, the mother of Mark Wilson. She spoke to him on the morning of the 27th and asked him, "Did you hurt those boys?" And when he told her yes, she grabbed her daughter Kayla and went to the sheriff's office. And she agreed to wear a wire after speaking with law enforcement to try and talk to Mark again. You saw the emotion from her and how hard it was for her to testify here in court that day. But she told you it was the right thing to do for Robert, Tayton, and Mark. She knew he was going to be arrested, and she still went to the sheriff's office because it was the right thing to do. And you heard this morning from Annalise Stratton. She testified that one of the placemats, I believe it was item 1.4, had a stain on there that came back, and it included Cindy as a contributor to that DNA. And the main witness you heard from would have been Detective Usina. He also agreed that it didn't appear that there was any cleanup around the bodies of the boys. He saw Mr. Wilson on the scene that morning, and he wanted everybody to know that Mr. Wilson was off alone. He wasn't near the family. He was shaking his head violently and crying. He saw him clinging to his daughter as if he didn't want to let her go. Detective Usina also agreed that everyone grieves differently. He found that odd the way Mark was grieving that day, but he did agree that everybody grieves differently. Detective Usina learned on the 27th that Chrissy Atkins had gone to the sheriff's office and made a statement. And he also became part of the takedown team, where he was actually one of the people that were listening in. It was him and his corporal and his lieutenant, or captain and lieutenant, that were listening in to the conversation between Mark and his mother. And the captain, lieutenant, and Detective Usina were the ones that made the call to do the takedown. He interviewed Mr. Wilson in the early morning hours of August 28th, somewhere around midnight till about 6 in the morning. And eventually Mr. Wilson confesses. And you heard what happened from Mark's mouth. He said, "I honestly believe they were. My daughter was being abused, I believe." Law enforcement said that they were abusing your daughter? Yeah. Law enforcement said physically, and then before he could say anything else, Mr. Wilson said sexually. And later you heard law enforcement say There's got to be a why. Are you protecting your family? He said, yeah. And then he said, my daughter is everything. Law enforcement said, do what? He said, my daughter is everything, man. Detective Usina says, I know, you already told me that. I'm not. And then Mark interrupts with fucking love. Detective Usina says, yeah, I'm not even going. I'm not even going to beat a dead horse. We're not going to. You did this for your family. Okay, I understand that. The court has already instructed you on that killing with premeditation is killing after consciously deciding to do so. The court has also instructed you that the amount of time that must pass between forming the intent to kill and killing must be long enough to allow reflection. Reflection is not what we saw in the interview. Where's the reflection? A reasonable doubt regarding a necessary element of the state's proof may arise from the state's evidence itself, as well as from lack of evidence or other conflicts in the evidence. Mark told Detective Usina that Cindy saw the boys after the offense. Mark did not know how the paper towels got bloody, but he told Detective Usina that Cindy helped him clean up. Mark could not remember putting the hammer and the knife under the sink. In fact, he said he didn't even remember going into the game room. However, you heard from FDLE analyst or Agent Morris and Corporal Higginbotham that the hammer and knife were found underneath the sink in the game room, and you saw photographs of it too. And you heard from FDL analyst Stratton today that Cindy's DNA was included as a possible contributor to DNA found on the placemats. I would submit to you that the true story is the one verified by the state's own evidence. That there was no plan, that Cindy found out after the offense and helped Mark clean up. And in doing so, she cleaned off the hammer and knife, put them in the placemats, and placed them under that sink in the game room. You heard from Sarah that Cindy did not wake her up that morning and ask for money on the 26th. And I would submit to you the reason Cindy didn't wake Sarah up to ask for money is because she didn't know if Cindy or Sarah would go back to sleep. And she may wake up and find those boys before they could leave to go to the doctor. When asked if he and Cindy talked about it and whether Cindy knew beforehand, Mark told them, meaning law enforcement, it was not something he planned on doing. I submit to you there was no plan, and the state has failed to meet their burden of proving premeditated first-degree murder. We'll come back to felony murder after we've talked about the underlying felonies of burglary with an assault or battery and burglary while armed. As you heard from the judge, the first lesser included offense of first-degree murder is second-degree murder. Second-degree murder is where a person is killed. The killing resulted from an act which is imminently dangerous to another and is demonstrating a depraved mind without regard for human life. To prove the lesser included crimes of second-degree murder, the state must prove the boys are dead by the act of Mark Wilson. And the unlawful killing of the boys was an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Mark told Detective Usina that he had been up for 3 days and he wasn't in his right mind. Detective Usina asked, okay, so when this happened, you're not pissed off and upset, you're just cold and numb to it. And Mark answered, that's what I'm saying, man. It wasn't me. I'm not like that, dude. Multiple deputies and detectives agreed there was no cleanup of the scene around the boys. The crime scene was disorganized or unorganized, and the crime appeared to have been committed in a frenzy. I would submit to you that Mark had a depraved mind when he thought he was protecting his daughter by doing imminently dangerous acts to those boys and causing their death. When you weigh the evidence for count 1 and 2, this is the crime that fits with all the evidence in this case. Let's move on to count 3. To prove the crime of battery with an assault or battery, the state must prove Mark Wilson Jr. had permission or consent to enter a structure owned by or in the possession of Chad and or Sarah Baker and Mark Wilson Jr. after entering the structure, remain therein with the intent to commit or attempt to commit a forcible felony. And those were listed in the jury instructions. Sarah Baker told you that Mark Wilson had permission and consent to enter their home. She told you that Mark and Cindy did not have laundry, did not have a bathroom, did not have a kitchen, so they had access to go into the house for those reasons. She also testified that at night she would lock all the doors except the side doors so they could come in and out and use the restroom and come in as needed. It would be for you to decide whether that permission was revoked. Let's move on to count 4. And to prove the crime of battery while armed, the state must prove Mark Wilson Jr. had permission or consent to enter a structure owned by or in the possession of Chad and or Sarah Baker. Mark Wilson Jr. after entering the structure remained therein with the intent to commit or attempt to commit a forcible felony. And like I just said, those forcible felonies are listed within the jury instructions. If you find Mark Wilson Jr. guilty of burglary, you must also determine if the state has proven beyond a reasonable doubt whether, in the course of committing the burglary, Mark Wilson Jr. was armed or armed himself within the structure with a dangerous weapon. Once again, as I just stated, Sarah Baker testified that Mark Wilson had permission to go in and out of the house, to use the laundry facilities, the kitchen, and the bathroom. It will be for you to decide whether the permission was revoked and whether Mr. Wilson was armed. Let's go to the felony murder. If the accused caused the death of these boys, in this case, while engaged in the commission of a burglary, he is guilty of felony murder, even if he did not premeditate the death. The prosecutor gets to address you again. They will no doubt emphasize an additional instruction the court has given you, which is that you should render a verdict for the highest offense proven. Let me again direct your attention to another instruction the judge has given you regarding reasonable doubt. If you believe that a verdict for a lesser included offense is the appropriate verdict, isn't that a reason to doubt the highest charged offense was not in fact proven beyond a reasonable doubt? Mark Wilson told you he did it. He owned up to what he did to his mother, Detective Usina, on August 27th and 28th, and during this trial. Mark Wilson was doing what he thought would protect his daughter from what he thought was further abuse. Remember during jury selection when you told the state that you would hold them to their burden of proving each and every element beyond a reasonable doubt. Today is that day. Today is that day to hold them to that burden. Look to the reasonable doubt instruction as a guide to determine whether the state of Florida has proven each and every element beyond a reasonable doubt. We all trust that you will hold them to that burden.
Steve, you're welcome.
Just give me the 10-minute break. I gotta set up a computer and.
All right, we can do that. So members of the jury, we're going to take a 10-minute recess. Please leave your notes and your instructions there on your seat and retire to the deliberation room, and we'll pick up again in about 10 minutes.
All rise as the jurors exit the courtroom, please.
Your Honor, defense would request article.
All right, let's go back on the record. Parties are again present, defendant is present, jury is out. You said you wanted the warning?
Yes, Your Honor, I believe it's when the state had started showing the autopsy photos that there was some audible weeping from the gallery, so I didn't think it was
I didn't hear
prudent
any
to
up here.
interrupt, so.
I didn't hear any up here, but I was observing the gallery, but I'll give the instruction.
Thank you, Your Honor.
Judge, one thing we read in the jury instructions, I think it usually comes out in a death penalty case, and that it's the judge's job to determine.
Yeah, I saw that.
So if we could just cross that out on the one we sent to them, or just black out through it, and then, it's not a big, I just thought when we sent it back. We should have caught it, just so used to the standard instructions. It's toward the
On
end.
page 42.
Yeah, must be afterward, yeah.
No, it's just before he read. It's before, it's like page 44,
42.
Yeah. What?
Right, I've waited it out. It's in paragraph 5 of the rules for deliberations. All right, so again, before we bring the jury out to the courtroom, spectators and families of the decedents, I want to remind you that this is a public trial open to all. Of course, please observe proper courtroom decorum. I am very sensitive to the fact that this case may evoke powerful emotions. Certainly may observe this proceeding and all observings in this trial, but you must not make any audible comments or emotional outbursts in the presence of the jury. These reactions may improperly influence the jury and result in a mistrial. If you do feel that the onset of an emotional outburst, please quietly and discreetly exit the courtroom, and you can certainly return when you're ready to do so in compliance with this instruction. It is my duty to ensure that there's a fair proceeding and uphold the dignity of the court. Any additional instructions or corrections that either party wishes me to make when the jury comes back out?
None from the state, Judge.
Defense?
No further, Your Honor.
All right, as soon as the jury's ready. Still working on it? All right, let's go ahead and bring the jury back in.
All rise, the jurors enter the courtroom, please.
All right, thank you. Please be seated.
Steve, you may begin. Thank you, Judge. May it please the court and defense counsel, ladies of the jury. So Mark Wilson is a protector and comforter. Does a protector and comforter do this to two boys? Does a protector and comforter go up and slit their throats and smash their heads in with hammers? Does a protector and comforter do that? No, you know who does that? A murderer. Someone who kills people with premeditation so that they're dead. That's who does that. Make no doubt about it. He is not a protector and comforter. He is a killer. And every piece of evidence in this trial points to that fact. There's no question in this case what happened. No doubt. We're supposed to prove beyond a reasonable doubt, and I submit to you, this case has shown beyond any doubt what he did on the 26th of August to those two boys. I'm going to just re-show you what premeditation is, just briefly. After consciously deciding to do so, he has to have some reflection. It's not a fixed amount of time. And most importantly, the circumstances of the killing and the conduct of the accused. Ms. Dunton went through an exhaustive list of premeditation, but because the defense wants you to believe that this is a second-degree murder, it is a second-degree murder. It absolutely is. But you know what else? It's a first-degree murder also. And your job is to return a verdict for the highest count. That's why second-degree murder is called a lesser included, because it's included in premeditated murder. That day, he was premeditated when he did that. He went and armed himself. We'll get back to this in a sec. He went and armed himself with a hammer. Why? Why do you have to arm yourself with a hammer? He armed himself with a knife, a sharp knife. Why? Is he going in there to build a shelf? Is he going to put a furniture desk together? No, he's arming himself with two different weapons. Each time he picks up a weapon, premeditation, reflection, consciousness, knowing what he's doing. There's no question he had what he in his mind what he was going to do. The defense wants you to believe that this was some just, it wasn't planned out, really detailed, and it wasn't this great murder. Well, remember what we talked about? It doesn't have to be a plan. It doesn't have to be something you're sitting around in the garage with Larry, Moe, and Curly coming up with. He made a decision, and if it was 1 second, 1 minute, 5 minutes, 10 minutes before, that is premeditation. So he arms himself, and the reason this is important, this is from the Faro scanner, and it's going to show you a few important distances. So from his room to get to Robert, who was killed first, is 30 feet. I'm going to show you what 30 feet is, ladies and gentlemen. Do I have enough time to contemplate thinking? Am I reflecting on killing these boys as I'm making this walk? When I just walked there for that 30 feet, I thought of what I'm going to have for dinner, what I'm going to stop at Publix to get, what kind of chores I'm going to do. I reflected and I thought what was going to happen. In that 30 feet from his room to going to Robert, he reflected, he made a conscious decision to kill the boys. And then when he gets in there, what does he do? This grown man takes this hammer, and he takes that hammer to a little boy sitting right against the wall, and he pulls it behind his head and smashes him. Do you think he had reflection? Do you think he had time to think what he was doing? And not only does he smash him once, he smashes him again and again while that little boy is sitting against that wall. And then what does he do? Does he stop there? No, with enough time to reflect, he reflects what he's going to do. And he decides he's going to slice his throat and he's going to stab and jab him multiple times. And I'll show you all those in a moment. Then, from Robert, what does he do? The distance to Tayton. He has to walk 22 feet to get all the way over here to interact with Tayton, where Tayton's first attacked. That was 22 feet. Did I have enough time to reflect? I had two weapons in my hand. I switched weapons. And what does he do when he encounters Tayton? Think about this. What does he do? Tayton's there, and Tayton holds up his hand. And this defendant slices at him, and Tayton's fighting. And he slits his throat, not once, not twice, but 3 long slashes to his throat. And there's multiple other sort of cuts to his throat, which I'll show you in a second, or marks that Dr. Fulcher told you about. And the entire time this is happening, what is Tayton doing? He's on the ground after, and he's crawling away. And he crawls away. Here's the distance of all the blood. It is almost 13 feet. Tayton has to go almost 13 feet to get away from him. And he's crawling to his phone. This young boy is crawling to his phone to call for help. He reaches to that wall, and his handprint makes a spot, hoping to get to that phone, while he's bleeding out half of his neck. And what does this guy do? This defendant, who's a protector, a comforter, he picks up this hammer and he smashes his head while he's crawling on the floor. Smash! Smash! How many times? A minimum of 5, up to 7 times. He smashes him so hard with that hammer that the head of the hammer, this head of the hammer, pokes and smashes through Tayton's skull. It makes a hole in his skull. That's how hard he's hitting him. And this guy's not premeditating. This guy's not thinking what he's doing. Don't fool yourselves for a second during his interview when he mysteriously blacks out. I don't remember. I don't know. He knows all the other details of the morning, but mysteriously, the details about the murder he did, he doesn't remember. He remembers getting up. He remembers having sex with his wife. He remembers folding clothes. He remembers going to the store. He remembers going to get coffee. He remembers they didn't have enough money. But miraculously, when he arrives home, the 10, 15, whatever minutes he takes to kill the boys, he doesn't remember. And think about this, our protector, our comforter. If he's protecting his daughter, did he wait there after killing the boys when the police arrived to say, hey, I did it because they were attacking my daughter? No. Did he call them 5 minutes after, 10 minutes after, 20 minutes after, 30, an hour, 2 hours? No. What does he do? When the police arrive, he's acting surprised. Oh my God, I can't believe this happened. He's an actor. He acted out amazingly 3 interviews with the deputy. I'm just so disturbed by this. I can't believe this happened to my nephews. And then, when the police interview him the second day, remember that interview, the first hour and a half. I didn't hurt the boys, didn't hurt the boys, didn't hurt the boys, didn't hurt the boys. He's laughing with the detectives. He's recalling everything. And then all of a sudden, does he ever admit in that time frame that he did anything? No. When does this defendant, the guy sitting right here, when does he admit he had a participation in it? It's not till they confront him with the evidence from his mother, right? That's when he does it. You know, it's not like this protector, this comforter, just strolled on into the interview and said, I did it. No, he lied, he lied, he lied, he lied. And I submit to you, ladies and gentlemen, once he was backed into a corner, he started to come up with excuses of why he killed the boys. Oh, they were harming my daughter. Really? Did he ever report that to anybody? Was there any evidence consistent with that? They did a full investigation, physical examination, and a rest of investigation. Nothing. Oh, but yeah, that's what happened. And the boys are sleeping with Cindy. Come on, is that believable? Use your common sense. A 12-year-old and 14-year-old boy, they're just having an orgy with Cindy? Come on. Does that make any sense? After he leaves the pool room, it is 40 feet to get all the way to where he hides the hammer, knife, and sheath. And he'll have you believe that he knows nothing about how that stuff got cleaned up, right? After this vicious, horrible murder, I blacked out. I don't remember. I have no idea. Is that believable? Or is it believable that he had enough thought after to go in there, take the paper towels, wipe them down, and he didn't put the paper towels in a garbage can right there, right? He didn't put it close to where the location where the knife and hammer was hidden. What did he do? Walked them all the way around, remember? So, kills the boys here, puts everything here. We have to go all the way around here to find the garbage can. Right. He didn't clean up any of the stuff. He didn't know what he was doing. Yet he went and took a shower. He got rid of his shoes. No one could find them. Got rid of his shorts. And he took Robert's phone. If this guy is so blacked out, so in whatever it is, why would you take Robert's phone? Makes no sense. And I submit to you the reason is, he was trying to make it look like someone else did it. Like someone burglarized the house, stole an item. Right? And the defense wants you to believe, oh, it's just such a disorganized crime scene. There's blood all over. You better believe there's blood all over. He just massacred 2 boys. What is he going to get the magic eraser out and clean up the blood and make it meticulously clean? No. What does he do? He covers them with a blanket to hide them. That makes no sense. There's no question he knew what he was doing. Knife, hammer. These are his items he used. We talked about this. This is the distance Tayton had to go to get away from the defendant. And he's fighting from this spot. See all that big blood, consistent with bleeding a lot right there? He's crawling and fighting around the corner, trying to get away to get to his phone because he thought it would help. Look at this. There's his print right there. Remember the Aaron Morris told us there was also a blood droplet right there? Look how close that is to his phone. This poor kid's getting attacked. And he's doing what we always tell kids. Call 911. Call for help. He's moving toward that phone. But guess who stopped him from getting to the phone? This guy right here. Because he's smashing his head in with a hammer. Let's talk about the premeditation. Each one of these wounds, and we're going to count them, each one of these wounds is another act of premeditation. Remember all these little cut, 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 cut? Dr. Fulcher told you he had to make that extra movement? Each one of those requires premeditation. They're all over the place. This is Robert. On his chin. His cheek. And then finally these blunt force to his head. And that's just doesn't stop there. He's got 21. And that's 21 times for this defendant to think what he was doing. 21 instances of reflection, 21 times of consciousness of guilt there, and conscious knowing what he's doing. Let's look at Tayton. Tayton had even more injuries. Remember all these little cuts Dr. Fulcher told us about and talked about. And this wound right here, 15 centimeters long. And it goes all the way to his back, almost to his spinal cord. It hits the front of the spinal cord. This is a vicious, violent slash. Along with this one, both of them would have killed him. But you can keep counting all the injuries he had. All of these. This is a little stab wound. Another stab wound, another stab wound. Each one of those required him to pull that knife out and do it again. Thought, reflection, knowing what he's doing. Each one of these. Poor Tayton had 20 injuries just on the front of his body. And then you move to his head, there's another. 25 minimum. All of those are premeditation. All of those are a process where he knew what he was doing. First degree felony murder. Let's say you go back there and you say, Mr. Lewis and Ms. Dutton, they're crazy. There was no premeditation, whatever. They don't know what they're doing. They got it wrong. Well, the defense has already conceded that he's guilty of second degree murder. So by that concession, he's also guilty of first-degree felony murder. And I'm going to explain to you exactly why. Robert Baker or Tayton is dead. That's a given, no question. While engaged in the commission or attempted commission of a burglary, Mark Wilson caused it. So the question is, what is a burglary? And we'll come back to that in a second. And Mark Wilson was the person who did it. So we know that they've already admitted he killed him. They know that the boys are dead. So was he committing a burglary? Let's go into what a burglary is. He had permission or consent to enter. You're dang right. Originally he did. The defense is like, Sarah and Chad said he can go in and out of the house. They can use the kitchen, the bathroom. Yes, he had permission or consent to enter a structure in the possession of Chad or Sarah, right? And then the defense said this. They're like, I'll leave it up to you to think whether or not that the permission would be revoked. Well, I'd submit to you, any reasonable parent, if their kid was getting attacked with a hammer and a knife and getting slashed, their head beat in, I'm quite certain no one's going to grant continued permission to be in the house. The question then is, after Mark Wilson entered that house, right, and he remained therein, did he have the intent, not that he did it, but did he have the intent to commit an aggravated assault, an aggravated battery, a manslaughter, a second-degree murder, or a first-degree murder? The defense has already said he committed second-degree murder. They conceded to this. So even if you say, Mr. Lewis, this done, it's not premeditation, they've already agreed it's second-degree murder, and by them doing that, he is guilty of first-degree felony murder. And how do we know what his intent was when he's in the house? Well, let's see. He pulled a hammer back, and he smashed their heads in. Let's see. He took a knife and stabbed them and slit them over and over again. I think it's quite certain what his intent was. Like I said, they admitted or stipulated to that second-degree murder, and I'm not conceding it's second-degree murder. Ladies and gentlemen, the judge will give you an instruction, and you are to choose the highest count, and that is first-degree murder in this case. So while he may be guilty of second-degree murder, that doesn't say he's not guilty of first. He's guilty of first, he's guilty of second. They're all inclusive. That's called a lesser included. They've conceded to second-degree murder, which equals burglary, which equals guilty of first-degree murder. It's guilty of first-degree felony murder. There's no question. This is one you should be able to go back there in 1 minute, look at it, and make that decision. There is no doubt in this one. And I submit to you, ladies and gentlemen, this is not a case where the evidence is difficult. This is a case where it's pretty straightforward, and it's a mountain of evidence. And this evidence shows he killed Tayton and Robert, premeditated and felony murder, and he committed those burglaries. There's no question, there's no doubt in this case. I submit to you, look at the evidence. Everything shows he did it. And they've even conceded to the second-degree murder. Ladies and gentlemen, this case is about those two boys. This case is about the premeditated murder of Robert and Tayton. Those boys slept in their living room trying to get internet. They thought they were safe. They didn't think anything would happen. Robert, he never woke up. Maybe it's good he died in his sleep. He didn't see it was coming. He was premeditated murder. But Tayton, he saw the eyes of that guy coming at him with a knife, trying to kill him. He saw it. And then while he's crawling away, while he's fighting for his life, that man right there, the protector, the comforter, which he's neither of them. He's a murderer. He's a killer. He hunted Tayton down like an animal, and he smashed his head in over and over and over and over and over again. Ladies and gentlemen, you came through that door with your common sense. When you go back in that room, you take the evidence and testimony and your common sense, and there is no question, no doubt in your mind, this is an easy one for you. You go back there, you find him guilty of 2 counts of first-degree premeditated murder, find him guilty of first-degree felony murder, because he did that too, and the 2 counts of burglary. Thank you.
In just a few moments, you'll be taken to the jury room by the bailiff. The very first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a chance to be heard. It's also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. Now, during deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. Now, all legal proceedings brought on behalf of the state of Florida should be conducted with a dignity worthy of that matter. As jurors in this important matter, it's your obligation to remain courteous throughout the process of listening to your fellow jurors and discussing your disagreements. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during these deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any instruction that I've given you in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring those devices into the jury room. So please take those devices out and leave them on your seats where they'll be guarded by our bailiffs while you deliberate. If you do need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer, and I'll answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent with you into the jury room with you when you begin to deliberate. States Exhibits 1 through 8 inclusive, 10, 12 through 27 inclusive, 29 through 31 inclusive, and 34. If you wish to see or hear any of the remaining exhibits, States Exhibits 9, 11, 28, 32, or 33, which are all either audio or video items, please request that in writing. In closing, let me remind you that it's important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived with the Constitution and the law. No juror has the right to violate rules we all share. If you would take your instructions and hand them down to the left end here, to your right, my left, and give them to the bailiff. They'll collect those up, and I will give you this copy here.
Here,
Yes.
the parties have noticed an additional instruction. I apologize.
Okay.
Go sidebar or.
Come up sidebar, please.
Thank you.
Going to re-instruct you on the verdict information. Please listen to this instruction specifically, and it will be included in the packet that I'm sending back with you. Now, with regard to the verdict, you may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. If you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that you all agree the state proved either first-degree premeditated murder or first-degree felony murder. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. I showed it to you earlier, and that will be going back with you. So I will be including this in the packet that goes back with you. All right, at this time, if everybody would please have your cell phones out and ready to give to Fidelis. We will retire you to begin deliberations in a moment. I'm sending a copy of the instructions, the original that I've just signed, a copy of the indictment itself, and the actual verdict form. Give those to the clerk. After we have you go back into the jury room, we will bring you back all of the evidence that is being submitted to you for consideration. So that'll be coming in just a moment. Since there's a fair amount of it here, it'll take a couple shifts to get it brought into you. When I dismiss you to begin your deliberations, I would like Ms. Farrell, Ms. Cody, Ms. Sutton, and Ms. White to remain here in the courtroom. You are the alternates. I'll give you further instructions in a moment. The remainder of the jurors will begin their deliberations, so if you would please, the rest of you retire to the deliberation.
All right, the jurors exit the courtroom, please.
No, we've got.
Yeah, hold on.
All right, so first let's return the alternates their phones. You can be seated, please.
Everyone have their phones? They're in there?
All right, if you'd like to step in and get them, do not talk with anybody while you go in and get them. I'll bring them right back down. Ms. Sutton. Thank you. All right, so you are the alternates in this case. Ordinarily, this stage of the trial, you would be dismissed and complete. However, as we mentioned to you during jury selection, there's the possibility of a second phase in this trial. As a result, we'll be dismissing you today, and you're free to go home. However, we will be in touch with you to let you know if you need to come back and participate in the second phase of the trial, as well as you may still be needed as alternates in that phase. While you're on this recess on your own, you're still under the same guidance. Do not talk to anyone about the case. Do not tell them if they try to approach you, tell them you're a juror that is still responsible for the case. Ask them to stop. If they persist, leave them. Please do not watch any news or press or internet articles or read any articles about this case at all. And don't accept or receive any messages or communications regarding your service as a juror. In addition, you're still not to do any kind of outside research into the law or into the facts or the circumstances of this case. We have already separated out your luggage, so what we'll do is we'll have you come through the courtroom and go out through my chambers, and they'll marry you back up with your luggage on the far side. We will not be starting phase 2, if phase 2 is indeed needed, until Monday the 24th at the earliest.
I think
Our
it's
jury
23rd.
coordinator will be in touch with you about that. Any questions with regard to those instructions? All right, thank you very much. You can step through this way, and the bailiffs will escort you back out to pick up your luggage. Leave your notes there as well. The clerk will collect those and will secure them for you until the next phase of your service is needed at that point. Thank you. Please be seated while we get the evidence checked out.
Jay, you already looked at everything?
I did, yes. Trinisha separated it all out. I told you. We'll probably need a lot more.
Your Honor, defense would object to the submission of the indictment. I do understand that some of the information has been removed, and then reviewing all of his previous objections. Primary or the new objection now is that it's not placed in evidence, so we would object, and then renewing all the other motions that were filed regarding the indictment.
State.
I would rely on my previous argument. It was never planned to be placed in evidence. In the previous motion hearing we had denying this motion was under the same box,
It's my understanding it's going back with the.
which is what you moved to not have happen. And you will overrule that.
That was a prior motion made before trial, correct?
Yes, Your Honor.
Yeah, I'm still adhering to that. They've had it read to them, but they deserve to see the writing as well.
No further,
I'm going to overrule their objection. Thank you.
nothing further from the defense.
Thank you. Oh, quick question, sorry, Teresa. With regard to the board that has the hammer and knife on it, any concern there?
I don't have a concern at all.
It's not a firearm.
No, Your Honor.
Oh, yeah, whatever they want.
All right, we'll keep that one out here. If they wish to see it, they can ask to see it. Just from a safety standpoint.
Is the packet and everything for them, everything involved?
There is already a folded question.
And can I just ask Veronica for a copy of the last 3 pages, because there's a reprint.
The question was, what was the height and weight of the defendant at the time of the incident? And our response to that would be they should rely on their own memory of the evidence at this point. Any objection to that response? I'll give it to them right
No objection.
Do you identify that as court's exhibit 1 or anything?
We will.
Okay.
It becomes a part of the court now, so it's not labeled as an exhibit.
Oh, it's not. Okay.
Parties want to review this response and then we'll have it handed in to them.
Okay, perfect. Thank you.
Acceptable to both?
Yes, Your Honor.
Thank you. And go ahead and hand that to them.
Can I see the question now? I want.
Ready to. Make sure the clerk has your contact information.
Yes, sir.
We'll stay close. Be in recess.
Thank you.
That man right there, the protector, the comforter, which he's neither of them. He's a murderer. He's a killer. He hunted Peyton down like an animal, and he smashed his head in over and over and over and over and over again.
The right to remain silent belongs to you. It doesn't belong to anyone else. It's not your turn.
Also would mark where I collected samples from or performed testing on these items. I also included the evidence tag here for any latent print testing. And then I also swabbed the exterior of this sheath, avoiding any red-brown staining. Thank you.
I thought that he was going to kill him by swinging a hammer and smashing him in the head over and over again. This is a case, if you go back and look at the Florida Supreme Court,